Hello there.
Hello.
Hello.
Oh, hello.
Hello.
All rise and like, subscribe, and bang the gavel, baby.
All rise, order in the courts, and we got potentially a good one. We're going to jump into it really quick because, as you can see, Meg, and if you've ever followed her, that Christopher Cannon dude, that's the one that she had all those issues with that time. You remember that video?
She doesn't like even being beside him, I think.
Right.
Can we move them apart?
Real quick, welcome. We got a case, Chases and Cases, 5 days a week. We start this off at 1 o'clock East, Monday through Friday. 2 hours of live courtroom drama. We'll try to keep it quiet, bounce around a little bit, but I want to start off here. It is landlord-tenant matters over at Judge Middleton's court, 3B. I want to jump into it because it's potentially can be good. You guys know we love Meg around here. I use that word loosely.
Mr. Reed's correct, Your Honor. I discovered that again recently.
Oh, did you just screw something up maybe?
And it's problematic that she's not
Already?
here. It's it's a hearing date for this. Pictures don't constitute pristine shape. I mean, they're pictures. The pictures are pictures. We don't know. I mean, maybe it is.
There are two issues. There's possession and then there's damages. So let's deal with possession.
I would
Ms.
take
Power, are you able to enter in a possession judgment on behalf of your client for immediate possession?
Kind of.
I do. Just to clarify, I did direct my client to appear, and I believe she is on her way to the courthouse. I don't believe there was any chance.
That's my favorite thing when we get to start and then it's just one of my fingernails on a black.
Right on time, Street Grain.
I apologize for not getting that out sooner.
Does a lot of
She'll be there
apologies.
very timely.
Uh-oh, he's on the phone.
A half hour.
I'm not waiting for you. Have we seen any sign of Diana Villavicencio?
Oh, we've heard that name a few times.
Not seeing hiding her hair over, Your Honor.
I just love Meg. I just plead not guilty. You're assigned Meg. You just go, I'm guilty. It's fine. It's let's do that. Let's just do that, please.
Meg's my lawyer. Go ahead and start packing.
So are we on the same page that we're talking about possession rather than damages at this point? If she were here, we could simply ask, do you agree to vacate? Then I can make a ruling on the escrow funds.
Well, Ghost, that
And
sounds
once
nice.
Plaintiff takes possession of the property, we could have further hearing regarding any money.
Hi, Carol.
Carol, good to see you.
Our friends from Keystone have joined us.
Oh, TJ's great.
Sandy Cook and Amy Lucas are here. Sandra had testified,
Yes.
I think, previously. The money was paid for January and February. In her letter of the 28th of February,
Make that money, Deborah.
she refers to receiving a check
Gorilla.
from Keystone.
Meg smells defeat in the water
Do
already.
you have any further information about any Keystone payment for March?
You en route. Yeah, I already did. The only thing that I know is we gave her a check of $2,475 to pay the landlord. So I had called her and
It's just
asked,
handing out checks, Creed.
given that money to the landlord because she was supposed to take it and put it in escrow at the courthouse. And when I
What was
went,
the date of that?
let me get the check.
Why do we keep allowing these people that have monies Now you go pay this, little Johnny. Am I alone in here? Hello? Is there anybody here? Hello? Hello? There's no Creed frame here, by the way. So we'll just keep doing this.
We're waiting.
While we're waiting for Creed to come back, we can jump over to mine. Small claims court.
See if she has in fact moved out, but I haven't
Welcome
heard
back.
a response. from
That's
her.
right. Going back to Creed.
I'm gonna take her at her word that she has. I guess we'll see what we've learned here.
Hello, Nate.
Nate the Great. Good to see you. Oh, ladies are switching up.
Yeah, it's rare we get to see both of
That was
Keystone ladies.
Switch hitting.
The check was for 7/9 of 21 that we had given her.
Or a Volkswagen. Maybe a Subaru.
It was because what we did was Christopher.
Look at Alexis.
you guys
Look at
sent the check
Alexis.
back
Look at
stating
Meg's
that
face.
They were not going to accept it. So then I
You
sent
best
it to
get
the
working, Deborah.
courthouse. The courthouse said that they couldn't accept it because it wasn't in the
Get
courthouse
to work
name.
now.
So I got it back.
Can you do
We
double
called
double
Diana.
shifts?
We voided that whole check. We made it out for
We're kidding.
Diana. She came and got it that day.
Went shopping immediately.
Huh?
What was the date of this newest check?
7/9 of 21, I think it was. That's what I got here, what Lisa gave me.
Oh, Meg said no. Mm-mm.
TJ and I both seem to.
There's no way that it was 7/9 because the check wasn't returned before.
Creed frame.
Yeah, I'm thinking it was January or something.
I don't have, Lisa doesn't have that on here.
You don't
All
have,
I know is I gave her a check for $2,475. She was supposed to take it to the court.
Well, she did make 2 installments of
Oh.
8.
I can tell the court that at the last hearing, we had the same issue where she hadn't paid escrow until the day of the hearing, or actually
Uh-oh.
after the hearing. And at that time, she admitted to getting the check 2 weeks prior, cashing it, but not paying the escrow.
Well, the total that was paid as of
Well, damn, Carol.
10/26 was $2,475.
See him
Correct.
rocking
She
an
paid-
older
The
caddy.
court had ordered, when the court entered the escrow order in December, the court had ordered November.
Oh, I'm so
and
sorry. I
December
missed one of
paid.
yours, our guy.
So that would, so November, December, January, February, but March is still outstanding.
He's
So
mad we didn't say hi
Okay, I
to him.
think we're in agreement.
Yeah.
But it does appear she took that.
Hi, our guy.
$275
Hello, our guy.
check and applied it to the
Not all of
Okay.
it. Not all of it. She didn't.
No.
She
So
admitted.
under,
March.
Under-
There was, as of that time, there was $2,475. Then
Thank
she
you,
made a
Carrie.
payment of 223 on 223 of 825. So that, I believe,
Right, but she had already made January's escrow before she received that check. So she received a check for $2,475 in February and only paid February's escrow.
Your Honor, can I?
I can't answer that. All I know is I agree with you that everything has been paid except March.
Why are we continually letting these people have the
Well,
money?
there are some payments that there is
I
about
know.
$600 and some lapse, that even if March were paid.
Yes, so there may be some further stuff. I didn't order that.
Your Honor, might I address the court?
No.
Yes.
You
Oh.
may not.
The complaint filed in this case was a possession-only complaint, seeking only possession. So the
Yes.
only issue here is whether,
Thank you, Ryan.
with regard to the escrow account, is whether or not my client complied with the order of the court and how much of the escrow should be distributed
That's why when I saw her, I said, we gotta do it.
to the plaintiff or otherwise. Any concern for back rent is not actually pled in this case.
That's
And
now
in fact, the court, I believe,
$128 you have
discussed
for this
that
month, Carol.
no- and the case law supports that no escrow order can, an escrow order
Gotta
for
put Carol on the corner.
this
Thank you.
can't enter. An escrow order is only moving forward. So looking at any outstanding rent prior to the date of the order is outside the scope.
Real quick, so I'm guessing that this is the continuance of the one that we saw, because that name is very, very familiar, and they seem to be kind of talking about the same thing. If you remember her talking to Christopher Cannon, it was about a check that was sent to them, and then they had to do some digging to figure out where the money went.
Order. I mean, she's never complied with the escrow order on time. She's not even here today. I would ask that the court enter a possession judgment effective immediately and allow the escrow balance of the escrow be turned over to my client, and then we will reevaluate the status of of the unit and determine any additional damage.
Welcome, Michael.
Brought on
I love it.
that of back rent.
Thank you.
So obviously, if the unit's in great shape and there's no damage other than standard wear and tear, the only issue is going to be that of back due rent. So, but we don't know that till we get inside the unit.
Your Honor, I
Just a
think that
minute, Just
Okay.
a minute.
Meg is only seconds away from either A, smelling something that stinks in her office, or B, crying on camera.
Well, did you just heard Judge Middleton? And he's already, you can just tell he's a little agitated. Just a minute, just a minute.
Oh, there she is.
That's
She
her.
made it. She made it.
Villa Vicencio or whatever, however they say it. She has appeared.
Ms. Villavicencio, can you hear me?
He did as good as you did, Creed.
Your lawyer, Ms. Power, is here. Mr. Reed is here.
Now they've been fighting this for a while.
And Keystone is here. We didn't want to sit around and wait for 15 minutes to see whether you were going to show up or not. This hearing is apparently a lot more important to the rest of us than it is to you. But your lawyer represented that you have completely vacated and cleaned the premises. Is that correct?
Hey, Jordan.
Do you have any objection to them having immediate possession of the property?
No,
All right.
Case closed. Now you owe us a lot of money.
I saw the pictures of the place you're moving to. It looks quite nice. We've been discussing the escrow funds. Ms. Bauer, I don't want to put it out here, but you have the defendant's new address.
I believe I do. I will get it and send it to the court.
All right.
But
Ms.
I-
Villavicencio, so do you consent to an order for immediate possession effective today, which is the 30th of March? So, Mr. Reed, I'm going to ask you to prepare a consent possession order for March 30th. I will also order that the escrow funds in the possession of the court, which are 2 checks for $825, which is a total of $1,650, be remitted to the plaintiff.
There's more than that in the escrow account, Your Honor. There should be 4 months total rent.
Well, maybe there's $3,300, I believe is what's in there.
That sounds about right.
The total amount, I believe it's $3,300, including what Lapidus. So escrow funds may be remitted to the plaintiff.
So he's getting paid.
Counsel shall forward defendant's new address.
Look back.
Y'all mean, man. Y'all mean.
I mean, it's kind of close.
I'd already thought about that, but y'all mean.
And any remaining damage hearing
Y'all mean.
or back rent or damage would be reserved for further hearing
Thank you.
if there is any.
Oh, do not watch.
Your Honor.
Do not watch yesterday's.
I don't understand why this case wouldn't be dismissed once possession was determined or established.
Mr. Reed, what's your thought?
Well, if she wants us to resue her client, we're more than happy to do so.
Oh,
You reapply the legal aid to get a turn. That's fine by me. I don't
Well,
know.
that would get us out of an accelerated summary proceedings case, which would actually give our client the opportunity to have discovery
They can elaborate.
and the other resources available in a general civil proceeding.
Well, we
Thank
can
you.
do that. I'm not.
Lambo goat.
They're gonna be so happy to put this matter to rest. It may be counterproductive to sue for 1 month's rent, and
Oh, there's more than 1 month's rent owed. There's July, August, September, there's about 3 months. There's several months worth of back
Well,
rent.
that's up to plaintiff. That's my rule.
TJ ready to rain on the parade at any
All
chance
right,
he
Mr.
gets.
Right.
Vincenzio, I can't give you a copy of that order because I don't.
And yes,
have it
Eric.
yet.
I think it'll be a
I don't know where to
revolving
send it
door.
to.
So I was going to submit the order directly to the court today, CC'd Ms. Bauer on the same, and it's simply going to be the court form for immediate possession submitted as though contemporaneous per the court rule. Obviously, Ms. Bauer has an objection. The way it's drafted, I'd ask her to flag it immediately, but I don't see any. I mean, it's going to be the checkbox form that the court generally uses.
Well, with the notation that escrow funds are remitted to the plaintiff.
Mr. Reed.
Yeah.
If it comes out that my client can get the keys to your client or your client's agent by the end of today, would you stipulate to set aside the judgment and dismiss the case if it's otherwise going to be dismissed?
No.
You want it on our record to damage her record.
Ms. Villavicencio has had ample time to get this matter resolved. This has been offered numerous times and she's rejected. She's drugged this out. My client has incurred additional fees beyond today now because of her lackadaisical approach to this case. I see no reason to do that.
TJ coming in
The
hot.
only reason she couldn't move into another apartment is because there was a supply chain issue delay, despite the fact that she signed a lease and paid a first month's security deposit on a new place back in February.
This was filed back in September the 8th of 2021. This is now March 30th of 2020.
No.
I understand.
Supply chain is well beyond not my concern.
I'll just file a satisfaction of judgment.
Oh,
Ms. Villavicencio.
That's her. Yeah, that's her.
Do anything.
Whatever.
don't back
Can't give you the
don't
order.
back her into a
Call
corner.
or Get it, and we'll make sure that you get a copy of it.
By the way, I'm watching court over here, the
Money
small
that
claims court.
you don't pay
I
that's going to-
I feel very confident that the
Reliable.
people that are
You voluntarily.
are here
pay-
in Zoom court are
They-
using computers at the library.
And
Oh, I believe
if
that.
there's any further hearing, it would be renoticed, and you'd have a right to have legal aid represent you if there's gonna be an issue regarding money damages. That'll be an issue for another day. This just has to do with the release of the escrow funds and the possession. All right, that concludes this hearing.
Your Honor, could you put me into a breakout room with my client, please?
Yes.
Thank you.
Meg, do you need to talk to Diana?
I can give her a call when she leaves the court, so we don't have to occupy one of your breakout rooms.
All right, well.
Like TJ.
I appreciate that, Bill.
I don't need all this breakout room BS.
Good luck to you, Ms. Villavicencio.
Diana might not answer your phone, but she'll answer mine.
Meg said, "Let me
What
get
about
the
the
hell out of
keyboard?
here."
Diana, can you drop the key? Is there a drop box or something there?
I went to the I went to the maintenance guy to give them to him, but he wasn't at home, so I said I was gonna try to stop back over
Did
there
you
later.
just, did you just lock them in the apartment?
I can do that too.
Actually, she doesn't need to lock it. She can leave them on the counter, kitchen counter, and then leave the door unlocked.
There you go, Diana. When you go back through, leave the keys on the kitchen counter and leave the door unlocked.
I like it when Christopher and TJ are in the same room together. This is the best. Their powers form such a incredible force.
All right. Amy and Sandra, thank you for your help.
Well, that was fun. We got to see the end of that. And that was a big deal, that case.
That case has been dragged on.
When you were released from custody?
Well, I asked Mr. Kingsley for an accounting, and at the time he told me it was my responsibility to get him the jail records and any other records I have of money that he spent on me. He told me it was my responsibility, and I disagreed with that. But I did not push the issue because I was living at his house and I needed a place to stay, and I knew he wouldn't allow me to live there if I did push the issue. Now, I did not know the extent of how much money he took because Marcia Fine and I never had a discussion about this until in March of 2019 where I found out that he did not give her the $3,000 he was supposed to. He only gave her about $600. And then finding out that he embezzled my Social Security payment right directly to his account.
Serious
I
charges
decided
coming
to
in here.
pursue it then and investigate more.
He's like a toothless
So,
Matlock.
when did you learn about the issue with Marcia?
That was in March of 2019 that we finally sat down and had a discussion about what he had given her and what he didn't. During that whole time, he told me that he paid her like he said, but he didn't.
And who was Marcia in relation to you? Friend, family member?
She was my ex-girlfriend,
Love
but I
that.
wanted to support her while I was in prison.
Hey now.
You
But
know
did
what we're
anything
talking about.
stop you from following up with her prior to 2019?
No, Mr. Kingsley played me and her against each other, and so I believed
Who
Mr.
objected?
Kingsley at the time, and I did not believe her. But after I investigated all this, it was the other way around.
I'm guessing it's something
How
that's
about
free
the
on an antenna.
embezzlement you're alleging? Did
Somebody having
prevent you
sex
from
is what's
learning
going
about
on.
Well, I didn't learn about that until
Going
after
pound town.
Marcia and I had our talk about how much
Enjoy.
he did give her and didn't give her. So then I went and I looked into my bank account and finally discovered that he did that.
He said,
Otherwise, I
reason
didn't
she's
look at
on
my bank
oxygen, Your
account
Honor.
until then. I thought, you know, he was being straight with me and
George looks a little ladylike.
George is
everything he
just
said.
off camera.
Okay.
All right.
Oh,
thank you.
it's definitely
So,
Matlock.
at
I
this
just saw
point,
the hair.
I've heard all I need to hear. The
think you
court
guys
is
are
going
right.
to make a ruling, and I'm going to give findings for my ruling. This is going to be dispositive. when
Yeah, there
this
he is.
conclude this
Matlock.
case. And that
But
means
she's
if
at a
I do
buffet and
not
has one
rule
of
in a
those
party's
spit
favor,
guards in front of her.
the remedy is to appeal this court's decision. And an appeal starts by filing a notice of appeal, which is done through our Clark County District Court Administration Office and must be done within 30 days of this court's decision. So again, Mr. Kingsley had moved for a continuance. He raised issues including
in the
statute of
library?
limitations.
I mean, am I
The
right? Like,
statute
you're
of
saying they're in the public
limitations issue
library?
I do find is
Well,
dispositive in this case. The court is
you
bound
talking
by
about George?
RCW
Yes.
416-080, Section 3. What we're talking about here is an oral contract. There
Gotta
is
be.
a written
Oh, an
contract,
oral
but
contract.
the written contract is a 2-page power of attorney, and it doesn't provide any substance as far as what Mr. Kingsley would be allowed to do or prohibited from doing as power of attorney. It only says he's to deposit or withdraw funds from this particular Umpqua bank account, which there's no dispute about him doing.
Thank you, Shirley, for the stars on the Facebook.
Money that is at issue here. That is something that it sounds like was orally discussed only. And that means a claim would need to be filed within 3 years of when that oral contract was entered into. The oral contract would have been entered into in 2016. We're now at the end of March 2022. So that statute of limitations has run. Now,
All this
Mr.
oral talk's
Bingham
getting
Heimer,
Chris worked
raised
up.
with the court that he didn't learn about any of these alleged violations of the oral contract until 2019. The question for the court would be whether anything prevented Mr. Bingenheimer learning from what he's alleged are violations of the oral contract sooner. So this was Mr. Bingenheimer's bank account. Nothing prevented Mr. Bingenheimer from having access to his
Hello,
bank account
Angela.
and see what transactions did or did not occur. So that wouldn't have prevented Mr. Bingenheimer from learning about it.
Both.
He said there were disbursements that were not made to Marcia, his friend or ex-girlfriend. Nothing prevented Mr. Bingenheimer from speaking to Marcia and learning about what was done or wasn't done. It was through finally speaking to Marcia in 2019 that Mr. Bingenheimer learned about what he's alleging as embezzlement. Again, nothing prevented Mr. Bingenheimer from reaching out to Marcia earlier or from investigating his own bank account earlier. So I can't find that there's any exception to that 3-year statute of limitations. And there's a reason for that 3-year statute of limitations. Again, we're going to be relying on what was said only orally between two people back in 2016. And it's a rather unfair position to be putting either of you in to try to remember what you said or didn't say in 2016. So the statute of limitations issue is dispositive. It prevents the court from proceeding any further. The statute of limitations has run in this case, and for that reason, I am dismissing this claim.
Wow,
So again,
dismissed.
Mr. Bingenheimer, your remedy is to appeal the court's decision. You talk to district court administration about how to file a notice of appeal. That has to be done.
I
within
did
30
a-
days of
I
today's
mean, I'm
date.
no lawyer,
I want
but
to say
Chris,
just
don't
first,
waste
as a
your
person,
time.
I can empathize with the real difficulties that come when you're trying to reintegrate yourself back into society after being released from custody. That's a big deal, and it's not easy. And you're trusting somebody with your funds while you're in custody. So I can appreciate on a human level, perhaps not wanting to look into this further while you were living with Mr. Kingsley. Like, I get it, human to human. But again, none of that would have prevented you from looking into this earlier. So the statute of limitations
Yeah.
has run, and that's why I'm dismissing the
Get George
case.
over here.
Couldn't she have just
Okay,
said that in the
we will,
beginning?
send
Like,
both parties
Let
a
him,
copy of the
you know,
judgment.
poor
Thank
Chris
you
is
all
over
for
here
your
begging for
patience and
money.
time today.
Yeah.
That's going to conclude this hearing.
let's jump over to felony first appearances happening right now.
Warrant read to you here in open court. Your attorney, however, has waived the reading of your warrant here in open court. Do you understand what you're charged with?
Yes, ma'am.
All righty. I'm going to hear from your attorney on the issue of bond. It sounds like they've already negotiated a resolution in your case. Go ahead, Ms. Mateen.
Yes, Your Honor. Miss Williams has been in Georgia for the past about 20 years. She's originally from Ohio, but she's been here for the past 20 years. She currently resides in Decatur with her children and her sister. She has 2 children, a son that's 12 and a daughter that's 10. She's currently employed as a chef. She works in Midtown. As far as I know, that this was a situation, as far as
Dismissed.
yes, so she's currently working as a chef. Her education includes culinary school.
Need a hearing
Like I
aid.
said, she's originally from Ohio, but she's been here for the past 20 years. Yeah, that's what I have for Miss
All
Williams.
right. Thank you. State, you want to be heard?
So much good stuff.
But
Heard
so,
you
Yeah.
out 3 times.
has an active hold out of Cobb for intimidation, and more information on that includes stalking from June 2021. So the state is agreeing to a UJR, but I don't believe that she will be released on that.
Deputies, can you confirm whether or not Ms. Williams has a hold out of Cobb County?
My God, was she yelling at somebody or what?
I know. I was kind of wondering why we're yelling, but maybe it's the volume in that big room probably isn't that good, though.
She was letting somebody have it. Can you tell me if she is in all kinds of trouble, like we saying?
The one before might have been. But seriously, if you know that this is a statute of limitations and you're just going to dismiss it anyways, do you let them go? I guess you do.
They had been on for the 20 some minutes of them pleading their cases.
I guess everybody has their day in court.
You got to make it a whole day.
Well, we are waiting on the confirmation of a hold in Cobb County, Georgia, I believe, right? Yeah. I want to say thank you to everybody. 106 of you joining us today. We do this Monday through Friday at 1 o'clock East. Jump around as much as we can. Really glad that we got Meg in this morning with that, because that is the other side of it.
I reviewed your criminal history. Based on my review of your criminal history and the representations made by your attorney, I am going to accept the resolution that your attorney has negotiated on this charge here in DeKalb County. And so I'm going to grant you that unsecured judicial release. It's a signature bond, which means you'll be able to sign your own bond. You won't have to come out of pocket any money. You won't have to go through a bonding company. However, the deputy has confirmed that hold on you out of Cobb County. So even though you bond out, you will not be released. You'll be transferred to Cobb County. You understand that, ma'am? You understand that, Ms.
Waiting.
Yes, ma'am. All right. So, Ms. Mateen, will your client be waiving the probable cause hearing?
Yes, Your Honor.
All right, Ms. Williams, my deputy's going to hand you an electronic signature pad so you can sign the probable cause.
Joe, thank you. Stars Facebook. You're awesome.
These biscuits is
right, Ms. Mateen, anything else on Ms. Williams?
No, Your Honor.
Ms. Williams, that concludes your first appearance hearing, ma'am. Please follow the direction of my deputy. Or as we have any other cases that we can address now that have a consent bond?
Yes, Your Honor. Position 20 or the add-on, Mr. Marcus Skeen.
I'm sorry, I thought that was a hold.
Yes, Your
Yeah.
Honor, I was about to say.
Are you all prepared to go forward on that now, or do you want me to hold it till the end of the calendar?
We should hold it, Your Honor, but it is a consent.
Got it. Any other consents?
I believe actually position 5, Your Honor, Tyreek Ford. We didn't get that over to Ms. Sapp.
Just do it.
We did agree with her recommendation.
All right, Tyreek Ford, come on up to the podium.
Come on,
Your Honor,
Tyree.
The state does not consent to a UJR on this matter. We have more information from the victims, and the state will be recommending a bond instead of a UJR in this case.
Ms. Mills, were you aware of that?
Not until just now, Your Honor.
Uh-oh.
I always like it when people negotiate in good faith. Just putting that out there.
Your Honor, I do apologize. This is the first day we're required to do court from office, so the commute took some time during the 1 hour of negotiation period. I'm sure this won't be a frequent.
I was going to say she's usually in like a haze.
Not in my courtroom.
It's true.
Ms. Mill, since it doesn't sound like you all have a resolution, I'll come back to position number 5.
Wow, she didn't like that at all.
Mm-mm.
I may not have to come back to it. Hold on. Y'all have any other cases that have resolved?
No, Your Honor, not outside of language line and the one we're holding. I think all of the others are contested hearings.
That or
Let's get Ms. let's get
they like to
Ms.
run
Ford
tight
since
ships.
we've already called them, and then I'll go
Some
back to the top of the
judges.
calendar.
And I don't blame them. After what we saw
Your Honor, that would
yesterday
be me representing Mr. Ford.
is a perfect example.
Oh, this is a breath of fresh air from yesterday.
Your client's charged in 2 warrants. You waiving reading of the warrants and the charges, the particulars in the warrants.
Yes, Your Honor.
All right.
Oh, I
Mr.
love
Ford,
that.
sir, you're charged in warrant numbers 22W 004733 and 22W 004734.
That was yesterday's. I think it was yesterday's poll
Here
question.
in open court, your attorney has
Kind
waived
of.
the reading of your warrant.
But no, we have.
in open
I
court.
have.
Do you understand what
I've
you're
never
charged
sued
with?
anybody.
Yes, Your Honor.
All right, I'm going to hear from your attorney on the issue of bond, and then I will hear from the state.
You deal with
Your Honor,
fresh
Mr. Ford
arrests
is
every day of
19
your
years
life.
old. He's originally from
Couldn't
Mississippi,
imagine.
but he's been in Georgia since he was 16. The address we have for him is in Stone Mountain, and he's been living there for the past 3 years with his mother. He actually has one child. It's his first daughter. She was actually born yesterday.
Oh.
So
Okay.
she hasn't even been
That's
named
the old,
like
the
that.
old adage.
Daughter. He was currently employed at the time of his arrest, and they are inclined to hold his job for him. His highest education level was 11th grade. That was in Mississippi. He according to Mr. Ford, he doesn't have any criminal history for the past 2 years. And we were going to ask for like $1,000, but when we saw that the state was recommending a UJR, we were willing to consent to that. But we were going to request $1,000.
She's an intern, by the way. She
Mhm.
just did pretty good. Or this
Yes,
guy just sounds all right.
Would you like to be heard on bond?
Yes, thank you, Your Honor. The state will recommend $5,000 and special conditions stay away from both of the victims, as well as mental health evaluation and treatment. Mr. Ford does not have prior criminal history, but our office was able to reach both of the victims and speak with them.
No, Jim, I forgot.
The first victim in this case
I will
is the
tonight.
defendant's father. Victim 1, Mr. Ford, is currently watching on YouTube. He has indicated that he's concerned that his son will be a flight risk if he's released. He will go to Mississippi and will not return to port.
Damn.
And the other victim was able to confirm that as well. She also said that she's concerned that the defendant will be a flight risk once released. Defendant's father also indicated that his son has had a history of violence. Both victims have asked for no contact in this case. So the state will be asking for that as a special condition. Defendant's father also asked for mental health evaluation and treatment.
Tell
That's
us more,
why
sis.
we're asking for it as well.
That's interesting.
Yeah, I like that. Is there any chance there'll be extra dono money in there?
For the special conditions?
Or
So, Your Honor, I have
McDonald's
spoken
fry
with Mr.
buckets.
Ford, and he himself said that he would rather have no contact with his father. He did mention that he did have some property over there that he would want to be able, if he was released on bond, just be able to just have like one trip and go get that. But he is not opposed at all to the no contact or to stay away from the alleged victim. That's his father.
That okay?
Ms.
That
Sapp, I'm looking
was
at
the
a
father that
defendant
said
who
that.
Yeah, when your dad says you're a history
But
of
he's the
violence and a
victim.
flight risk. Yeah,
And,
Dad's the
based
victim.
on what I've heard, I'm struggling to understand why
Wants to see him
the
in there. You know
state,
what I mean?
or rather, the parents through the state believes he's a risk to flee or have a history of violence or needs a mental health evaluation. That's a lot for somebody with no history, at least no documented history. You want to elaborate?
I understand, Your Honor. I updated.
That's the problem. I don't. I want to understand.
Your Honor, I updated.
I like
this
her.
recommendation based on the additional information
sassy.
we had from our contact with the victim.
Once again, the communication process is broken down.
What's happening?
All right, Ms. Mateen, so given these facts and the restrictions under 17612 for UJRs, it sounds like the state did not even have the authority to offer a UJR bond. So in that respect, I am going to allow the state to withdraw the offer. However, I think the state is asking a whole lot without a basis for this court. So I am going to set bond at $1,500 because I am concerned about the allegations here and that your client may be a danger to the victims.
Yeah, she does wear something on her.
$1,500. It will be a regular bond. So that means you should be able to go through a bonding company to exercise that bond.
Yay.
I am going to grant the state's request requiring that you stay away, absolutely, directly or indirectly, by person, telephone, and any other means of communication from the person, home, job, or school of Eugene Fort Jr. and Clarissa Ingram. You will be permitted one trip back to the residence to remove personal possessions, but you must have a police officer present. That's even if nobody is at home. If you go back
I got you
without
to
a
that.
police
Yeah.
officer present, that will be a violation of the special condition.
Yeah.
Let me help you understand what stay away means, because I'm real strict about this.
Probably.
Stay away means this. It means no talking, no texting, no tweeting, no sending messages.
No flowers.
Sending flowers.
Otherwise.
Don't be sending your dad no
In
flowers.
contact with Mr. Ford or
Dearest
Mr.
Pops.
Whatever kind of contact, whether it's direct
FU.
contact or indirect contact. The contact alone is enough to violate your special condition. And if you violate the special condition, two things can happen. This bond can be revoked and you'll be facing additional charges. Do you understand that, sir?
What's going on, bud?
All right. State, I am going to deny your request for a mental health evaluation. There's just no basis for it. And so,
Your Honor.
no.
Your Honor, I apologize. I received additional information on that. The history of violence is out of the state of Mississippi.
Here's my problem. You've hijacked the defense and now you're hijacking the court.
The state resident
I'll hear from
on
you.
this case.
I'll hear from you.
He was previously hospitalized
I'm listening.
at Georgia Regional for mental health issues. That's the information we had from our contact with the victims. But we will be recommending a special condition of mental health evaluation and treatment if needed.
Don't cry.
Boy, that escalated quickly.
You want to be heard?
Your Honor, this is my first time hearing about this, so I'm not sure. Like I said, I've spoke with Mr. Fort, and I know the state mentioned. I've never heard any of this before. This is my first time hearing this.
You want to be? You want to respond to what the state said? Because it's my first time hearing it too. Anything else, ma'am?
In terms of the mental
not
health
happy.
evaluation, I haven't discussed any of this with my client, I know that we can definitely fine with the no contact to stay away. In terms of the mental health value of y'all,
Yeah, here's my problem, Miss Sapp.
But wait, there's more.
I think I just have to say it again. This is the type of information I think would have been helpful to the defense so that they could enter into meaningful negotiations with the state. And so to spring this on the court and their attorneys at the last moment is I believe is just fundamentally unfair. More importantly, I'm placing a special condition on Mr. Ford that requires him to stay away from the victims. So to the extent that the victims are concerned for their own safety, I believe the court has addressed that. If the victims are concerned about his mental health, that seems a bit inconsistent with not wanting him to be around, but then wanting him to go and take care of some mental health evaluations, which were only recently disclosed at the very last minute. And so I'm going to deny the request once again for the mental health evaluation. Ms. Mateen and Ms. Ford, if you all believe, based on what you've heard today, that you need to encourage your client to get a mental health evaluation, feel free to do that. But the court is not going to order that based on the information presented at the last minute. There's nothing in the warrants that indicates there may be something mentally health based.
Wow.
And there's nothing before the court other than some information from some people who are not here. And so I am weighing that. Please don't get me wrong, because this court takes mental health very seriously. There's a lot of stuff we take seriously, but we just don't throw terms around just because we can throw them around. And this court doesn't put folks under orders that could potentially set them up for failure just because somebody somewhere said something. And so I'm going to deny that request. Mr. Ford, your bond is set at $1,500. It is a regular bond. That means you should be able to go through a bonding company. As a special condition of the bond, you are required to stay away. Absolutely, directly or indirectly, by person, telephone, and any other means of communication from the person, home, job, or school of Eugene Ford Jr., Clarissa Ingram. You will be permitted one trip back to the residence to remove any personal possessions you may need, but you must have a police officer present, even if no one is at home. That is the order of the court. Ms. Mateen, will your client be waiving probable cause?
Your Honor, we like to reserve.
So we're going to reserve the probable cause hearing. Mr. Ford, my deputy's going to hand you an electronic signature pad. I'm now ready for you to sign that special condition.
Wow.
That was a banger. And for those of you who don't know, ADA SAP works very closely each and every day here. So it's not like she's just somebody that just showed up.
Right.
So that was very interesting. I don't have enough understanding of law as to exactly what happened, but I have a pretty good understanding that she basically threw some info that probably should have been worked out beforehand.
Well, Creed, she did have an hour-long commute to the office today.
You are not.
She was not expecting to have to be at the office.
She did say that.
All right, you're not waiving, is that correct?
Yes, Your Honor.
All right. Anything else on Mr. Tyreek Ford?
No, Your Honor, that's all.
Mr. Ford, that concludes your first.
SAP, anything else?
Please follow the direction of my deputies.
Score one for the public defender.
Going to be coming back to position number 2, Gerard.
All right, let's jump up. That was a good one. Where we at?
Prosecution
Okay.
decides about what
We're in
cases go
district court.
forward and what
BRB.
not. The court can't
Go
just
right ahead.
summarily on its own motion dismiss
In case
things.
everybody's
There has
wondering where
to
we
be,
are, we are in
a hearing and evidentiary basis.
we're
And
arraignment calendar here.
prosecutors
Thurston.
will be reviewing that. If they haven't already reviewed your point of view, I would think talk to you some more and make decisions about whether they're going to go forward or not. And they
And I
haven't
just
presented
Judge No
anything
Name
to the court
on the bench.
to
I just
make
found
that
out
change.
yesterday that I could do a motion to lift the order. But I mean, I've been asking everyone and I just found that out yesterday. And Sharon said she'd send it to me via email, but I still haven't got it. She told me she would
Sharon,
send me
the
Zoom
oldest
link
practicing
with this,
attorney
and I
in
never did
the
get
US.
it. I called their office, gave me the wrong Zoom link. So I had to call somebody else to get the Zoom link, and that's why it was in so
Send me
late.
all the
But,
details. I need to know this
I
off
don't
the
know.
record.
I just don't know what the correct steps to take to.
So we're set for
I'm
April
on
13th. Can
PHR,
we give
for
you
mental health. I'm schizoaffective. I see and hear and think things that aren't there and true. And
Yolanda coming in hot.
I run amok in my brain when I'm not on my medication, and he is basically a victim of my madness. And I
Are
feel
you back
horrible.
on your medication now? Or things kind of settling
Yes.
down? Good.
She don't trust
So
you.
we're going to be back April 13th. This is my suggestion to you. And I can't order you to do anything, but this is my suggestion.
April
So
20th.
the court can't do anything unless all the parties know what's going on. So if you wanted to file,
Good for
call it a
Yolanda
petition
being able to say that
writing
she's
to
got
the court.
issues.
And it sounds
Good for
like
her.
Ms. Clausen, Sharon Clausen's going to send that to you. She works with the prosecutor's office. You can get it from the court directly. Write out whatever you want the court to know about this order and whatever you're thinking. And get it in before the 13th, and then the Ms. Wagoner can look at it, the prosecutor can look at it, the court will look at it. We'll hear from you if there's something more that day. And right now, that's a release condition on a criminal case, the no contact order. So we would consider that on the 13th. But we would need you to
So I
kind of
just
get
do-
that in. If you could get that in like the week before, that would be great.
I told her I would send it back in last night, but I never got it. So
Okay.
do I just send it to one time and then it gets sent to everywhere, or do I have to write
Send to
each
the
one?
district
each
court.
place?
Yeah, you can, let's see, if you're comfortable sending things, to the district court, you can walk it in, you can mail it in, you can email it in. We've got live chat on our website at the district court. They'll help you with
I
that.
emailed it last time, but my question is, do I just do it one time and, to one place and then they get distributed?
That'd be
or-
fine. Just send it to the
Okay.
court.
I'm
'cause
guessing
everyone can
Yolanda was
access
off
the
her
court
meds and
file.
hurt somebody.
Okay.
So Ms. Barker,
I believe we set them on April 20th.
oh, April 20th, I'm sorry, yeah. I've already forgotten. April 20th. So if you can get things in by April 13th, that would be helpful and everybody can look at it. We'll bring that up. So we'll set it on with that thought that we're going to probably hear from you in writing.
Mhm.
All right, so just send it to the court, and then attorneys, feel free to hop into the court file anytime and look at everything and be ready for that potential on the 20th.
Yeah, I've never
Yeah, I see that.
had domestic violence or anything, and I just knew it'd get him in trouble. I didn't know that it would just be a snowball effect, and I need to fix that. I feel bad.
All right, and the court will hear from you, so on the 20th, so just, that's all you gotta do is just get that information to the court. And Ms. Clausen's a good resource to get that petition.
Nathan called her.
or Just contact our district court directly.
Let
And like
the
I
record
say, you
reflect
can
he did
call,
so.
You can go live chat on our website, you can stop in, whatever works for you.
Thank you very much.
Sure, all right.
Tom's
look
just
forward to
waiting his
seeing you on
turn, by the
20th.
way, Lynn. He's
All
just
right,
like,
so then Ms. Wagoner, anything else here?
I don't believe so. I appreciate your words, Ms. Ostrom, and I will keep an
my
eye out
internet
for
doing that
anything that
again?
you submit. And I will see you all back on 420.
Okay.
Yeah,
so Mr. Avery, I just
420
wanna make sure
everybody.
I've got good contact information. Mailing 7625 19th Lane Southeast Apartment 203 in Lacey.
Yes, ma'am.
All right, and let's see, did you want a text message reminder of future
a
court
lot of
dates?
seems good to go. with
Yeah, I
meds.
believe you guys do that already, which is very helpful.
Okay, so you got it. Great. We'll keep doing that then.
All right.
That's it for today. Then just be in touch with your attorney.
Thank you. Have a great day.
Thank you, Mr. Avery. Thanks,
Thank
Ms.
you.
Ostrom. Have a good rest of your day.
Creed, enjoy the rest of your day.
You too. Thank
that-
you.
Is that everybody? I mean, we got
Can I
Tom
see the
here,
back
needs
of
some
the
help.
text, so we can see that. All right. And
Yeah, good for
then
Yolanda for
10:30, Mr.
owning
Bernberg
up
has been there a
to-
while.
She stepped up.
You're the
She said, "Hey,
10:30
this is it."
matter. And you're muted, so I can't hear your profound statements.
Oh, am I undone now?
Now I can hear you.
I had it
Okay.
exactly backwards.
Tom's quite the.
Your Honor, I'm here this morning on Thomas Humphreys. He is present by Zoom. Tiffany Goldsby, who is his companion, is also present. Your Honor, we're here this morning. We've made two motions to the court. We're asking the court to do two things. To
Slow motion,
modify
yeah.
the no contact orders, 3 no contact orders, one with his companion, 2 with his children. We're asking the court to modify those to a no hostile contact. And also there's the court has ordered Mr. Humphreys to wear
I just want you to see this live shot right now. It's just, it looked like he
now,
was asleep.
John, we go back.
He may be.
I guess, I'd like to begin at the beginning. 3.2 says that, we're supposed to ensure that a defendant returns to the court and that the community is safe and does not interfere with the administration of justice. That's the purpose of the rule. And the court, if there is a danger of any of those things, the court can impose conditions. 5 months ago, when Mr. Humphreys came before the court had some concerns, and it's certainly well taken and understood. During that time, Mr. Humphreys has had an alcohol evaluation. He's entered into treatment. We've had progress reports filed. He is in full compliance. I had a new one in March. Again, he's in full compliance.
You're lying, Kieran.
He's also had an evaluation and entered into domestic violence treatment. So he's got 2 treatment programs going on simultaneously. He's in full compliance with both of those. When he got out of jail, his company, he's a very valued employee. He works at Manatee Lumber. He's a welder, and they held his job for him. He's a very important employee there, and they held his job. The problem there is that with the ankle monitor that he's wearing, he's required to wear boots, given the nature of his job. The ankle monitor prevents him from wearing those boots, which he could be fined for, and not to mention he could get broken toes or whatever. There's also the danger of tangling up in hoses as he's climbing over big equipment. And if he was to tangle the ankle monitor with the hoses, he could be injured. Your Honor, Mr. Humphreys has very little criminal history. I think in 96, he had a deferred prosecution. In 08, he had a DUI. And then in
Can we come up with something for
I think in
Tom?
Shelton Municipal
Like
Court, there was an allegation of
monitoring
domestic
belt?
violence, which was subsequently dismissed.
Uh-oh.
So
Okay.
in 7 years, he's had no criminal
He's a
history.
pro.
Now,
Chase
during that
Cameron's
time
got a
also,
weak
the
neck.
court may recall that Mr. Humphreys had a son who was killed in a house fire.
Oh my
And,
gosh.
Already had
But
one.
an alcoholic, Your Honor, is somebody who cannot not drink. And in this case, and it doesn't matter what we tell them, you're going to go to jail, you're going to lose your job, whatever, and they continue to drink. And an alcohol monitor won't stop that. It'll let us know that they did, but it won't prevent them from drinking.
J-frame.
In this case, Mr. Humphreys has been over the last 5 months, has got in 2 treatment programs, has maintained his job.
It's almost like his house is in a vehicle, isn't it?
It's like,
bumps.
is he in an RV right now?
I think at this time, when we go back and look at the purpose of Rule 3.2, I think the court can safely conclude that he's not a flight risk. He's lived here his whole life. He's not a danger to the community. I mean, he had some issues in his life, but he's addressing those issues. And he's abided by the no contact order, so there's no threat to the administration of justice, no public safety. I mean, he's done everything a person can do. And I think at this point, lifting the no contact orders would actually be helpful in his treatment programs that he's doing. So given all of that, I think
does
Jay
really live in a 1-bedroom apartment?
In lifting or modifying the no contact orders and lifting
He
the
lives
requirement
simple,
on the
Creed.
ankle bracelet. Again, Your Honor, if it's not going to keep him here, and it's not going to keep him from drinking. Let
He's
us
got the
know that
Murphy
he
bed
did.
pushed into the
But
wall.
we don't need to monitor his whereabouts. We know where he is. He's in treatment and he's at work. And if he's going to drink, he's going to drink. He's an alcoholic. That's what they do. But he hasn't drank. He's doing a really good job.
He's
And I
a
think
drunk,
when we
Your Honor.
balance his safety and job requirements versus what the ankle bracelet actually provides to us. I think it kind of weighs more in favor of taking the ankle bracelet.
If I was Tom, I'd be like, hey, Jay, can you
With that,
please
Mr.
stop
Humphreys
saying
is
I'm an
available
alcoholic?
for questions for the court. Ms. Goldsby has written letters, as has the rest of the family, asking the court to lift the no contact orders. She's available to answer questions as well, Your Honor. Thank you.
Well, your motion, you said you attached documents that I don't see attached in the court file. That would have about the treatments. So I wonder, that would be helpful.
I don't know what happened there, but I do have them here and can
got 'em
absolutely
somewhere,
get
Your
them to the
Honor.
court. I have the progress reports from STOP and also, which is his domestic violence treatment, and then Northwest Resources, which is where he's
I got
doing
him right
the
here somewhere.
alcohol treatment. And the progress reports all indicate that he has attended all the meetings. He's attended all of his
Light bill didn't
AA
pay, Your Honor. Hold
meetings
on.
and outside help he's required to do so. I can provide those to the court. However, I can't assure the court that those have been done.
Can you, are you able to maybe get those emailed right now to all sides?
Yeah,
so we
yeah, I
look
can
at them?
scan them and email them right now, Your Honor.
That'd be great. Why don't we
Hope
do
Tom
that? And then I'll
doesn't
take
drink at
this
that American
case
Legion.
while you're working on that. Then
Okay,
we can all
and what
look at
email
it.
address should I send those to?
Let's see. You want to send him a chat? Bailey's going to send you a chat with that info, and then you can get
Hi.
that to us.
Great, thank you. I'll have it
And we
right
can
to the.
share it with the prosecutor who's here in the courtroom. And then we'll
Great.
jump back to you and your client and Ms. Goldsby. But right now, I'm just going to jump over to
As we
Mr.
just learned,
Russo
JT.
for 11 o'clock or 10:30 at 11.
Good morning, Your Honor.
Hi.
David Lusto on behalf of Casey Jones. And we're here on the defense
The
motion.
Ninja
asking
Turtle
the
guy?
court to rescind the no contact order. My client's
there
in
he
an
is.
in diversion, a friendship diversion. He has also,
Is he here
Look at
somewhere?
Tom's
I think
face.
he's on Zoom, Your Honor. There we go. Hi, Casey.
Popped in.
There he
Casey
is. Okay,
Jones.
Mr. Jones. All
I
right.
believe that
Grateful
the
Dead
alleged
fan.
victim of Krishna intends to be on Zoom. I don't know if she's actually on or not.
Yeah,
First thing.
I
Them-
do see.
them
I
books
do
will
see
not
a
pass.
Krishna Jones.
There
All
you
right,
go.
we've got everybody here, and this is on a diversion. And your request is to do what? Sorry.
Is
Good
to
old
ask the
Jake,
court to
scrambling
fully
for
rescind the no
papers.
contact order. I know that's what Krishna wants. My
I
client
think Jay
wants
may
that.
have
My
had too much to
client
drink
has done
last night.
a DV assessment with Cynthia Norris at Alternatives Professional Counseling in Olympia. I have a hand copy of that if the court wants to see it.
Let's
I'll provide it
jump
to the
from
state.
drunk
And I also
court
have-
Go ahead.
over to Washtenaw County. Looks like a nice cast of characters.
Reverend Stewart's back, I see.
Uh,
You've seen him before.
Judge Archie's hair is on point today, by the way.
From the date of the applicant's convictions to the filing of the application warrant setting aside the convictions, and it is within the public welfare. Therefore, it is ordered that the applicant is granted, the application, is granted as to all convictions listed in item number 1, as well as a separate order for issuing misdemeanor marijuana possession. And that under Michigan law, that being MCL 780.623, Michigan State Police shall maintain a non-public record of the conviction and of the arrest, fingerprints, conviction, and sentence in the application of each case to which this order applies. As such, the court will sign this order.
Can we get the judge off drop?
Making his rounds today, I guess.
The companion case the court finds that
Yeah, why do you ask, TK? Everything's fine here.
the court finds that an application to set aside conviction was filed on August 24th, 2021. That the crime so charged was under 333.74032D. That the prosecutor's office was given an opportunity to respond to the application, and it has been 60 days since the date of service of the application. No answer has been.
Did somebody sue a refrigerator?
Today, March 30th.
Billy Fridge.
And that the prosecuting attorney has not proven by
Go on.
the evidence that the application
Somebody change Archie's battery, please. He's getting pretty slow here.
on conduct that would constitute
Wearing down.
with the law of the state of or political subdivision of the state, as it has been committed on or after December 6th of 2018, as to all such convictions.
Okay.
And that the application is granted.
Your Honor,
Yes.
could I say something?
Yes, sir.
Sarah Lee, ladies and gentlemen.
Applied for that, and I also reapplied for the state emergency relief also, and I'm waiting to hear back from both of them. So I just wanted to let the court know that I applied for both of those.
Miss Lee, is that going to be a problem?
If you love
he's gonna get
ceilings, we
denied
got
for Sarah
some.
Because
Yeah, we do.
he's got a SER application in.
I don't believe so.
Yeah, I have a caseworker, and they said that it was fine to apply for both. So
We could get a floor over
Thank
at
you, sir.
Margaret.
It
No, I guess
sounds
it
like
is.
that is correct. So we'll see you back here on May 4th, 2022. Make sure you stay in touch with your caseworker. Okay.
Spark
this-
Rob
Thank
is
you.
here, by
Thank
the way.
you,
Your Honor.
May 4th.
Yes.
What time?
Who's talking?
Look them up on
It's
SoundCloud.
I just wanted to tell you that I in fact have a tenant that applied for both, and you can apply for both.
All right.
And yes, I
thank
do
you, ma'am.
smoke 4 packs of cigarettes.
All right.
I am smoking
So
in court.
it's at 1 p.m., sir.
May 4th, 1 p.m. Thank you, Your Honor.
All right. Thank you.
Is this where we were yesterday, Cluster F Court?
No, this is different. I mean, we're in. This is a little bit of
Recalling the
tenant
case of McKinley
stuff.
Co. versus Mackenzie McCune, case number 22C0436.
Your Honor, for the record, Carissa Gazzari, appearing.
Wind him up.
Ms. McCune, please state your name
I
again.
did
for the
see
record.
Judge Simpson is
Mackenzie
about to
McEwen.
go live.
Yeah, I
too.
got him. I got the prosecutor and an attorney on, and we'll wait for some customers
she
to
did,
arrive, and we'll jump over there.
Offer a payment arrangement. I would like to adjourn the hearing 1 week for me to talk to our client and see if they're willing to do this payment arrangement. And if they are, then we would just
Don't
submit
ya?
a conditional order of dismissal.
Don't you want to?
April 13th. I'm only doing emergencies on the 6th. at this
Okay.
point. So
Okay, that's
April
fine.
13th, 2022. And that is at,
People are coming in and out so quickly.
Oh,
right
I know.
now.
It's just constantly moving.
Just,
Thank you.
just go ahead and.
And even
We're
some of the
anticipating
better
those
ones
for
are still bad.
persons
Like Christopher is still like
Danielle,
all crooked.
Mhm.
C0562.
Good afternoon, Your Honor. David Banter on behalf of the plaintiff.
Good afternoon, Kingsley Udella.
I mean, David looks good. Parissa, I
that
believe
all
her
good.
name is. Look at Denise is
All right.
almost on point,
We're
even though
here
she's
after-
way down.
Well, we were here last week. Where
Mhm.
was Mr. Fantera? You may proceed.
Mr. Udella did not have
I think we have
their
a
application at that.
customer over with the Honorable J. Cedric Simpson, ladies and gentlemen, one of our favorites around here.
Devon over here already playing the I'm religious card.
Oh yeah, want to get that cross in there. Yeah.
This is a holy household, Your Honor.
You already have one?
Yeah, for Southfield.
Are you on a sober link tether?
Yes, I have to go report through Southfield.
For what charge? What kind of charge?
It was
Mr.
disorderly. It was like a disorderly conduct.
Nothing serious, Your Honor.
Are you on an alcohol monitor under that case?
It's not a monitor. I just have to go into a testing facility. And,
How-
and I have to blow.
But
And I
how
have to
often
do
are
it.
you going in?
We all have to at some point, son.
It's twice a month.
Okay, that's
And
not
it's
gonna,
that rank.
that's not gonna work under my standards on an OWI. He's gonna need to get the sober link. He doesn't really have to report with the sober link. He just has the machine with him. He will have to come in maybe once a month to download the data, but I mean, we get the data anyway.
Then you can get that 500 pages.
Enjoy that.
Could you give me more than 24 hours? Because I currently have my son with me. And
You got
I'm probably-
24 hours. You
I
want the
can't-
number to community. Probably don't want to tell me that you can't. You want the number to community correction services so that you can make arrangements with them?
could you send it to my attorney?
I think you're right, Joe.
Council, that number is 734-973-4520.
Is he driving?
Judge Simpson not
What do
playing.
you mean?
He's an attorney. Come on now.
He knows the number. Back
Back
in
case, people versus Daniel McDade.
Where you at, Daniel?
Nobody don't want none of this today.
It's kind of weird being in his courtroom
Your Honor, I represent Mr. Data on the felony case.
without a ton of people, you know?
Which is here for arraignment on a bench warrant. I'm not sure if you called the felony or the misdemeanor.
Okay, hold on. Who represents him on the other one?
Sure, that's what I was thinking.
She's in a. Okay. All right. Well,
I was just gonna say, can somebody tell Caitlin to like do a little better with the hanging wire there? Really annoying me. I have OCD.
this come in. Just me.
Emily's here. BRB.
Go right in.
I'll let her in. It's locked out.
Who did? Mr. Adams did.
Judge Simpson really not messing around. 150 of you here. If you could do us a favor, like this video wherever you're watching from. Share it if you're on
Before I do
Facebook.
anything on either one, Mr. Adams. Felony. Okay.
No BS today, guys. He is not playing around.
Were you aware? Not the way things are going today, but were you aware of a violation of his conditional release?
Yes, Your Honor, we're aware of the fact that he was to report on a regular basis to community corrections. He failed to do that. He's also had police contact, which led to him being hospitalized. That was on the 17th of March. He was in the hospital.
17th or 18th?
Well, it could have been the 18th, Your Honor. He was
That's a nice looking sweater on Daniel. I wonder how I would look in that.
Friday, and thereafter he was with his mother for 2 days, and then started at Spera on the 20th of March. For the last 10 days, he's been at Spera. He was evaluated late yesterday. I got the paperwork today for him to participate in their I'm sorry, it's called the
Go on, Stephen.
Stabilization Program. That's a 30-day program, inpatient at Spera. You also see, and I forwarded this to the prosecutor just recently, a letter from Community Mental Health. They have evaluated him as well, and he qualifies for their CARES program, and he'll be treated with them as well. So what we're asking the court to do is maintain the status quo so that he can stay.
Really don't know yet, but he's got to go to treatment for something he did.
Condition and perhaps
Guessing
schedule a
some
bond review
alcohol
in 30
offense,
days.
maybe.
Yeah, that's what I was thinking. If you're doing inpatient stuff and all that.
Oh, I'm sorry. My phone's ringing, Your Honor. Hello?
I will cancel the defendant's bench warrant on this, on the felony matter. I will set a probable cause conference because here for his other one. What day did you go in, young man, to the program? Start the 30-day program?
That 30 days is going to start now, Your Honor, today. He went into the program 10 days ago, but that doesn't count towards his 30 days. He has another 30 days starting now.
10 days
Is that correct, sir?
That's what?
You're muted.
Yes, Your Honor.
Any objection from the people?
Oh, Your Honor.
3 days. It is 28. Well, all right.
Yeah, he's
I'll set a
definitely.
probable cause conference for May 5th.
10 days don't even count towards the 30 days.
I won't set an exam date. I will indicate that I'm
No,
adding a
actually, that's
condition.
good for him if he's
I'll
doing.
set the defendant's bond at $10,000
he's
personal
doing.
recognizance.
The more
I'll
days you're
add,
in, the better it is. For you.
I'll reinstate
In the
previous conditions.
And in some states, if you're doing
Your
treatment,
Honor.
that'll count towards your sentencing.
Yes, sir.
Weeks.
They also will be drug testing me and alcohol testing me every week, and I can send those to community corrections.
Yes, get those over to community corrections, okay? It's probably best that you contact community corrections, let them know where you are and what you're doing, and then, or Mr. Adams can do that. They may need an order from me. Sometimes they'll do it, sometimes they
Hey, that's
want
cool.
something
Say, hey,
separate,
Cat.
so whatever they need will,
Hi, Aunt Cat.
in order for them to accept the testing, okay?
I sent Ms.
Very convenient that he's
Well,
going
yesterday
in today.
Said she's out.
Since
till
he's got a bench warrant
Packs with the two drug deeds.
for
The
him.
Prosecutor have now too.
Oh yeah, that was
Right,
planned.
but they won't, sometimes they won't accept them without my order. So we'll
and
figure
he
that
did
out.
detox
So
for 10
I'll
days
continue,
so
I'll
that he could
reinstate the previous
pass a
conditions.
drug
I
test,
will
apparently.
add that defendant is to continue in the, I'll just indicate the spare program, and that's through Don Firearms. He's to continue in that program and any aftercare. You understand that, sir?
Yes, Your Honor.
And then I'm also trying to understand this. So you also are with CMH?
Correct. I have a thing, it's called CARES team. So I have a counselor that I'll be speaking to once a week while I'm here, a psychiatrist that's going to give me a monthly medication review for my mental health. And I'll also be given a case manager.
I wonder how.
Okay. So what I'm going to do is I'm going to indicate as a condition of your bond, you're continuing the CARES program through CMH. Okay.
Okay, Your Honor.
So I want you to continue in that programming. Okay. And I want you to get through the spare program, and they're going to have something for you after that. You got to do that, and you continue to do testing in there. Okay.
Okay.
And
Yeah, they recommended 30. They recommended intensive outpatient when I complete this, so I plan on doing that as well. Of course.
Okay, so whatever the follow-up is on that, if
True.
that happens,
Gotta start
and you
somewhere.
finish this program and they've got you going into intensive outpatient, don't wait on a separate order from this court. That's what I'm saying. Whatever is called for after that, I want you doing. Follow
Okay.
me?
Yes, Your Honor.
Okay, and then we will see you May 5th.
May the
Anything
5th be
further
with
on
you.
this case?
No,
May
thank
the
you.
All right, Mr. McDade, good luck to you, sir.
Oh, hi, everybody. Okay. I just want to listen what was happening. I love you. And who's handsome? I
Yeah,
do have
Mr.
keys to my
McDade.
house, but he
You gotta
locks
stick
the
around.
screen door, which I do not have a key.
Yeah, I'm
Okay,
planning.
good. Good. I wanted to wish you good luck on that, but you got to stick around. That's your other thing. Okay.
Thank you, sir. Thank you, Your Honor.
Yeah, I like
Waiting. Mr. Kleeman is still.
I like the screen door,
Okay,
so
that's not baking bread. It's
'cause it's
making-
easy.
Creed, can we jump to mine real fast? Popeye
Yes,
is being
absolutely.
arraigned.
Okay.
Popeye is
Videos,
being arraigned, and I can't
whatever they
believe
may
it.
have.
I mean, he is really.
I expect the video, the USB to be returned hopefully by the end of the week, or maybe next week, just so if I can have like maybe 3 weeks.
Okay, Mr. Faria, April the 20th.
Yes, sir.
April the 20th at 1:00 PM. For status. Okay. Anything else you have, Mr. Palacios?
I have nothing further before this honorable court judgment.
Sir, I was gonna ask you if my mom could pay the bond or whatever.
I'll speak to her, Judge. I'll speak to see what I can do if there's any reductions or anything I can see for. So I'll go see.
Or we'll get with you on that, Mr. Montes. Your lawyer will speak with you later. Thank you.
Thank you, Judge.
I've got Cynthia Del Bosque in cases 46 and 47, the state versus Jocelyn Castillo. In the female
Wow.
section, deputy, do we have in the alpha female section, do we have Jocelyn
Alarm.
Castillo there?
I saw there's a lot of action in Louisiana today.
Oh yeah, this is getting hot over here too, man. You should see it. It's dark and cloudy. Something's gonna happen soon. Here comes one of the
Ready?
alpha women with all her cats.
Is the defense ready, Mr. Bosque?
Defense is ready, Your Honor.
Okay, you're Jocelyn Castillo for the record. Is that right, ma'am?
Imagine the chafing on his.
Yes, sir.
Okay, you're in the alpha section of the jail appearing by Zoom and you understand English. Is that correct?
Sir.
Okay, what is the status of Mr. Bosque?
Your Honor, on this particular matter, the state and I are still negotiating or plea bargaining. If the court can give me just a short reset for about a week or so, I think we should be able to get this matter resolved.
Okay, Mr. Padilla,
April 6th at 1 o'clock.
April the 6th on both cases, 46 and 47 at 1 o'clock PM.
Yes, Your Honor.
We got the
Okay,
Fox
she's,
section
Ms.
and the
Castillo.
Alpha section.
You're gonna be remanded to the custody of the sheriff. Your lawyer will get with you and discuss the status of the negotiations. Okay, ma'am?
Okay. Thank you, Your
ma'am.
Honor.
You're
Having no
excused.
further business, may I be excused?
Is he sparking one up? What is he doing?
He's literally like sucking on the end of the pen. It's very weird.
He's got a severe oral fixation, Creed. He's
I-
insatiable, some would say.
He's
42 and 43.
Court's gonna call case 42 and 43.
I wonder if this Padilla
Versus Emilio
is
Sanchez
related to the Padillas that
Indiano.
were on a
State
few different
ready on both
reality
cases?
shows and that
State
are
is
big
ready on both
bondsmen
cases.
in
Is the defendant
Texas.
ready,
That's
Mr.
right.
Redondo?
The defense is ready, Judge.
Mr. Guillermo is Spanish speaking, Your Honor.
Thank you
Anybody
very much.
remember who I'm
The
talking
record
about?
reflected Emilio
Padillas.
Sanchez Anguiano is
I think that was in
appearing
Texas.
by Zoom at the Fox section of the jail. He does not understand English, so the
Fox
interpreter bailiff will interpret all proceedings. Just for the record, your name's Emilio Sanchez Anguiano, is that right?
Yeah, I was seeing
That
where
was
they're
Emilio
saying upwards
Sanchez
of
Anguiano.
90-mile-an-hour winds potential.
Okay, Mr. Arredondo, what is your announcement, sir?
Judge, I spoke to Ms. Maldonado 2 days ago just regarding this case. I have received the
I saw he had retired.
TDC reg, Judge. I just need to
From
visit with
acting
my
for a
client
while.
to see if he's gonna want to take it, Judge, or how we're gonna proceed with this case, Judge. I
How
didn't.
much time do you need, sir, for that?
Excuse me, Judge?
How much time would you need for that, sir?
3 weeks, Judge. I should be able to dispose of it within 3 weeks, Judge.
Okay,
Oh,
let me
God,
go ahead and set him for April the 20th at 1 o'clock in the afternoon. So he's, your client's remanded to the custody of the sheriff and you're excused, sir, and I don't see you having anything else. Is that right?
He does, sir. He has number 52.
Oh, sorry. Sorry, I missed that. Case number 52 is CR 925-20J, State versus Pablo Alberto Flores on a plea. Is that still ready for a plea, sir?
No, Judge. Your Honor, this is the case. Judge. We received a recommendation from the state judge, but this is the, Your Honor had told us just a while back that Your Honor is willing to consider between 10 or 12 years, Judge. The state is recommending 20. So we're just asking for a 3-week recent, Judge, so we can sign him up. It's gonna be a plea to the court.
Okay, let's see, go ahead and let's see, April the 6th. How much time did you need?
2-3 weeks, Judge. If I can get that April 20th setting.
All right,
should
they're
be able to
just,
take care of it by then, Judge.
Yeah, they're just
April
burning
the
through. Yeah,
20th,
if you want, if you got something, go ahead.
Heidi,
That'd
good.
be for
Maybe I man, I
rearrangement,
met that. Anybody
Yes,
else
sir.
follow
Report,
that Casey Anthony trial?
okay.
I did.
Any
I
objections?
yeah.
Maldonado?
watched
Oh, yeah.
so much.
No,
of it.
Judge.
All right, thank you. Okay, you're
Thurston
excused,
County
Mr.
Court
Arredondo.
District. We
I
got
think
a
that's all
double
you have, is that
banger
right?
I have
happening over
one.
here.
It's a 2 for Wednesday.
That's right. Got 2 in the clink and
1 in the stink.
one,
Oh, sorry, that's something completely
2.
different.
Yeah,
I
wrong
really
show,
meant that.
Mikey. That's tonight,
I-
8:30. The return of the OG show. By the way,
I really
hopefully
messed
with all
that
4
up.
of us, at least 3 of us.
Well, that gives you reason to tune in and find out. One of these guys is doing his own thing.
Oh, I did see some things on the in the group, the StreamYard group, that some people were having some issues. And of course, it was deflected to their internet and Wi-Fi settings. It's not them.
Of course.
No surprise. Yeah, that was insane. And that reminds me, I meant to watch some of the things that they had, the documentaries and stuff. Forget. There's been a couple of good ones from what I understand. I guess we're not
The
really
judge
doing
is
anything over here.
eating lunch at the moment.
I'll be on standby, Judge. I'll be on standby.
That's fine. We're gonna go to a staffing with Mr. Munoz, and then I'll come back to that case, Mr. Rosado.
I'll be on standby, Judge. No worries.
Thank you. Okay, Mr. Padilla, if you could put Mr. Munoz and Ms. Maldonado and myself on the Kevin Eloy Santillan case.
I think the judge's clock is broken over there. It's not even swinging. Yeah.
He probably doesn't have it plugged in since he's. I would have meant. I don't know if he's working from home or not, but those things make a lot of noise. Let's go back to Judge Williams, who we're on. ADA SAP has not been terminated as of yet.
Oh, she wishes she had.
Refer to it and use it against you. I'm happy to give you a call as soon as court is over and answer any questions, but I do strongly caution you to speak in this setting at this time.
Now, having heard from me and your attorney, ma'am, I don't want you to leave this courtroom thinking you cannot be heard in this public setting. You still want to address the court?
Please.
No, ma'am. Okay. So, based on what I've my review of your criminal history, you have cases out of Alabama, Tennessee, North Carolina.
North Carolina.
You have 2 cases pending recently out of Tennessee. I don't think that's enough ties to the state for me to seriously consider a UJR. So I'm not going to grant you a UJR.
We use StreamYard, it's called.
Case, it appears all of this arose out of a traffic stop. And so for that reason, I am going to set your bond at $2,500. It will be a regular bond. That means you should be able to go through a bonding company. I'm not going to place any special condition on your bond that this court will not be able to monitor. So your bond is set at $2,500, regular bond. Ms. Milt, anything else on Ms. Turner?
No, Your Honor, nothing additional.
So, in reviewing your warrants, ma'am, I did notice that there's an allegation that you were in possession of somebody else's identification. I don't know if it's true or not, but that person was named in the warrant. So I'm going to, as a special condition of your bond, I'm going to require that you stay away. Absolutely. Directly or indirectly, by person, telephone, and any other means of communication.
Again, no flowers.
From the person, home, job,
absolutely no flowers.
There are no exceptions to that special condition. So my deputy's going to hand you a signature pad so you can sign that special condition. Doesn't mean you agree with it. Simply means I've gone over the terms with you and you understand what your limitations are.
Is it me or is this Miss Mills down here? Kind of look like the daughter on the Roseanne show.
Special conditions been signed.
Which one?
All right, Ms. Mills, anything else on Ms. Turner?
The black-haired one with the very
Ms. Turner,
curly
that
hair.
concludes your first appearance hearing. I'm going to ask
The
you
one
to
that
please follow the direction.
is on the View or something now.
Yes,
yeah, I can see that. Yeah.
Janice, it's going to be 1,000 on the false ID document, 1,000 on the meth, and 500 on the insurance charge.
Yeah, Jay.
Put in her place, Darlene.
Darlene, but with some, with blonde hair. I can totally see it.
There you go, Jay. Jay knows what I'm talking
Sarah Gilbert. Thank you, Terrell.
about. See, everybody's on the same page.
Abby, this is in Georgia. It was first appearances with felonies.
EWI is slowing down in the afternoon like it normally does. Y'all give me just a little bit of patience and grace, please.
Or just move on to the next, as she was saying. Righty, Baldy. Hello, Greg.
Mr. Booth was right. I mean, I should have done this prior to all this. But like Miss Palladino said, I mean, it does take a person who struggles every day of their life a couple times to actually get it right. Because I mean, there's no
Is he in
wrong,
a
no
mosh
right. You
pit
know what I
right
mean?
now?
Life isn't yes and no. It's for people who struggle every single day of their life. It's a lot harder. But I mean, I do thank God I finally got the help that I'm getting.
Wow. Now I know what I would look like with no facial hair and my head shaved.
When's that appointment set for, Ms. Palladino?
Not bad.
April 15th, correct, Mr. Foster?
Yes, ma'am. And they do random drug tests. Every week when you come in, you see the doctor, they give you a drug test, and then they call you in just to give you a random drug test.
Those sons of
drugs ain't
bitches.
What I need, you know what I'm saying?
Wherever Jessica is at, are they very prone to flooding? Is that why you gotta plug things in waist high?
Well, maybe she's in a garage because there's a power box right there on the wall too.
During that period of probation, sir, you are not to violate any
It's the circuit breaker right there.
Government. You are not to leave the state of Michigan without the consent of the court. However, you may live and travel in the state of Ohio. You currently reside in Ohio, correct?
Yes, sir.
Okay, so you can live and travel in Ohio, but you can't go outside of Ohio or the state of Michigan without permission of the court. You're to make a truthful report to your probation officer monthly or as often as your probation officer may require. That's either in person, virtually, in writing, however they require you to do that, you need to do that. You're to notify your probation officer immediately of any change of address or employment status. In order to pay the following, you're to pay a crime victim assessment, which is mandatory of $75 and the state minimum cost of $50. Fines in the amount of $300 and costs in the amount of $345. That's a total of $770.
Ooh, there you go. Thank you.
Your supervision fee, you have to pay $30 a month times your 12 months. That's an additional $360. So altogether, you owe $1,130. We're going to require that to be paid.
Can I drop that off today or
6 months of probation?
Don't I have a bond of $2,500?
There's a $2,500 cash or surety bond here.
George, Greg there just looked over like, why would you bring that up?
I believe that was by a bonding company. Bond would be released, but that's between you and the bonding company, sir. I don't believe he posted that personally.
My God, Deborah, is that true?
$1,130 total fines, fees, and costs.
I didn't know that.
And those need to be paid within the first 6 months of your probation.
Yes, sir.
You also have to serve the following: 365 days in Monroe County Jail as follows. You serve.
Can I just get
90
that
days.
$2,500 back from my
Impose
bond I didn't post?
180 days jail. Credit for 23.
JG. That could be. Or like a laundry closet or
Balance
something.
of 185 days that you would serve if you violated probation. Now, the 180 days is going to be served as follows.
Yeah, he's like, can we just use that bail bondsman's money to pay the keep change, Your Honor?
Does he report to probation and then to the jail, Mr. Abood?
About time we're 140 of you with us today.
That took
Report to
forever.
the Probation department by 9 a.m. on April 1st, 2022. All right?
Yeah.
Mark that down. That's very important. What time are you going to report to? Report at
9 a.m.
Will you be
This
drunk or
Friday.
high?
Yeah, Friday, April 1st at 9 a.m.
Yep, and the court's going to require
A shirt and tie. Very formal.
that you serve the initial.
I like that he's trying to get himself in rehab instead of
14 days
jail.
in jail.
Yeah,
2
well,
weeks
it's a
in
lot
jail.
cheaper, I think.
Be released on April 14th.
All right. I've heard enough
2022.
about that. And Lambo Red is absolutely correct. Most importantly, though,
The balance of those 100.
ladies and gentlemen,
Most importantly,
Lisa's here
that he
and
was-
back from
Oh.
flushes.
Lisa.
So we had been talking about that, and when he was found, they were gonna see if they could find him a bed so that he could go through that program.
Lisa,
I
just a
haven't heard
quick
from him
wave. I know you're
recently,
watching.
So I can't say whether or not that's. going
Rub your
forward.
nose right now.
Just a quick.
A
Your
loving
Honor, if I may,
glance.
I can speak on that if you need clarification on that.
Please.
Yes, Your Honor. So what Mother's talking about is inpatient treatment at TYRC. They did previously
She has a
have a bed
sweet voice.
available
She
for
could
him. However,
suck
since
me
he
to
was
sleep
in
at night.
abscond status, they had to let that bed go. But I am able to contact them again to see if we can set up another interview with him. See if we can get him set up with inpatient treatment again.
Unfortunately,
Okay.
JG. Yes.
Then, based on the information provided in the detention hearing report, I'm going to find that if I were to release you, Pierce, you would be a danger to yourself. I'm going to order that you continue to be detained. However, I'm going to authorize his transfer.
There's no point. There's no point, bro. There's no fucking point. Man, fuck this shit. Certify me, bro. I ain't doing this to the dog.
Pierce,
Fuck this
Pierce,
shit.
Pierce,
You
you need to
badass.
sit down.
Because I just started taking medication. I just started getting my head right now. Y'all gonna
Pierce,
let me know, bro.
Pierce,
Bro.
Pierce,
Bruh.
It's not working yet.
No, like this is the
Pierce.
first time I'm actually mentally clear, and y'all gonna
Pierce,
like
you
what?
need to, Pierce,
Bruh.
you need to calm down, sit down, and shut up.
Bruh. You don't understand. Like,
Actually, I do. You're the one who doesn't understand.
shut up.
This is not Burger King. You don't get your Whopper your way when you want it. And your conduct will be taken into consideration by this court on how this court decides
Dad burns.
by your probation. If you act like a little 2-year-old, I will treat you like a little 2-year-old. Given your outburst, you will remain
Level
where
4.
you are. As the adults in the room consider how to proceed. We'll revisit this in 10 days.
Throw
Now
the
you
chair.
are dismissed, Pierce.
Another happy customer, as they say.
All right. Is the correct pronunciation of your name Nema?
Yes, sir.
All right, Nema. My name is Judge Porter. The law says when you're brought in.
Name of the bar has been
You
set
judge
very
the
low, so
business
you're
day.
good.
Now, we've had a referral that you're previously placed on probation by another county, and supervision of your probation was transferred.
We're not jumping.
us.
I just want to show really quickly.
You have some
Range, and he
information.
also indicated
You may
he's
have
not a
violated one or
radiologist
more
either, and he
conditions
didn't
of
review any of the
probation.
films. We did
that
have a
information
radiology
to the
expert who
originating
did
county.
look at the films, who
Based on
said
that
the
information, they
the
asked for
radiographic
us
findings were consistent with degenerative disc disease and not traumatic related, and they had no
detention here today. According to the offense report,
Nothing needs to be said.
the information that I have
Nope.
indicates you tested positive for methamphetamines, MDMAs, other drugs, and you've been skipping school and failed to complete your community service as assessed by the originating county. So on the basis of the request by that other county, I'm going to find that if I were to release you, that you would abscond from the jurisdiction of the court and that you would be a danger to yourself. And as a courtesy to that other county, I'll order that you be detained here. I'm not gonna answer your question today, but Ms. Lazarova will get in contact with you, and she can probably answer your questions for you. If there's anything she can't answer for you, she knows how to get in touch with me, and then we'll work from there. Okay?
I have a question. Well,
Well, I
yeah,
want you to hold off on answering your questions.
Hold on that
There's
meth
a
talk.
DA who's listening in, and I don't want you to say anything that might hurt your case. Okay?
Unless it's an actual question.
it's because
Okay?
Shut
I want you to hold off and ask your question of Pavlina for me, okay? Don't ask me now in front of all these people where the DA's taking notes. Will you do me that favor?
Darcy just done with
Thank
her
you.
YouTube
That'll be the
stream
order of
of
the court.
how to do hair and
Thank you
makeup.
so much.
Lisa
Thank
just
you, Pavlina.
pounded that drink.
Darcy, I mean.
BRB.
Good day, sir. Mom's in the house?
Efren,
Yes, Your Honor.
we know each other. My name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And I have not seen your attorney, Kathy Lothorpe, here this afternoon. Kathy, are you here? She may be in another court. Okay, I'm going to ask Darcy Deno, another attorney who regularly represents kids in our court, to step in for Ms. Lothorpe. Good afternoon, Ms. Deno. How are you?
Good. Thank you, Judge.
All right. Efren, you're here on unlawfully carrying a weapon, theft of a firearm, and tampering with identification numbers. The court has previously found that probable cause exists to believe that you may have engaged in delinquent conduct sufficient to warrant your initial detention. You have a hearing scheduled in front of me on May 9th. According to the additional information provided in the detention hearing report, mom's found alcohol in your bedroom. Your mother notes that you may have needed to see a doctor, but she hasn't taken you to see the doctor, and that you're being homeschooled to prepare for a GED. Are you mom?
Yes.
What kind of workbooks is he working through for his GED?
I don't know the name of it, but he's got all the workbooks at home.
Okay, what is he doing to prepare?
He hasn't been.
Oh, okay. Well,
And he has a doctor's appointment on already scheduled.
When?
April 28th at 11:30.
Okay. Well, it's real important to me that he go to school, and apparently he does not have suitable supervision to which he is amenable to make sure that he completes his schooling. So I'm going to order that he remain here because I can make sure that he goes to school here. Yes, Mr. Spence, how are you?
Yeah. I'm doing fine today. Hey, the mother would like to make a statement real briefly about the condition of his grandfather.
This is not the appropriate time for statements. We can save statements for hearings other than detention hearings. This is solely limited to whether probable cause exists or to whether he should be detained or not. And the court has already made its detention hearing.
Yeah, and I'm pretty sure he just
All right.
made mention that
Save your statements.
he
Thank
doesn't
you,
have
Mr.
suitable
Spence. That'll be
supervision.
the order of the court.
I think that's what he's talking about.
Morgan.
Yes, sir.
Morgan, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And your attorney, Kathy Lothorpe, could not be here this afternoon, so I'm going to ask Darcy Deno, another attorney who regularly represents kids in our court, to step in for Ms. Lothorpe. Good afternoon, Ms. Deno. How are you?
Good afternoon. I'm great. Thank you.
All right, Morgan, you've got a motion to modify hearing scheduled in front of me. In a couple of weeks, you're on probation with Judge Terry for assault, family violence. And we currently have information that you have a history of skipping school, running away. And Ms. Thomas, did you have a resource staffing today?
She did, Your Honor, and a placement search will be done.
All right. Well, Morgan, based on your history of running away and skipping school, I'm afraid that if I were to release you, you continue to skip school and you might abscond from the jurisdiction of the court. You can't do that because that's not in your best interest. So I'm going to keep you here today. Thank you. Thank you, Ms. Deno.
Moving them in, moving them
Ms.
out.
Thomas.
Thank you, Your Honor.
Okay.
Hi, Grotto.
Isaiah.
Yes, sir.
Isaiah, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And we've appointed Raymond Daniel to represent you. Mr. Daniel, are you here? Oh, give me just a second. All right. We have two people who are identified as iPhone. You have 30 seconds to change your name to your correct name and not iPhone. If you fail to do that, you will be removed without further warning. This is your one and only warning.
30 seconds.
Letting Raymond connect.
How do I update that? I'm sorry.
Okay. I'm going to remove iPhone number 1. Okay. Good afternoon, Mr. Daniel. How are you?
Good point, Nancy.
I'm fine, Judge.
There we are.
Let me move out.
Those are people down there before they
we
bring
go.
them in
I'm at another
to the
courthouse,
main
actually.
Zoom.
All right, Isaiah, the court has previously found that probable cause exists to believe that you may have engaged in delinquent conduct sufficient to warrant your initial detention. So I won't go into the basis underlying. While you're here, you've been level 1 outstanding for the last 3 days or so. Ms. Brazel, does he have a parent or guardian here today?
Yes, his mother is in the family room.
Mom, I know that you and your son, as well as I think he and his brother have been talking while on the phone while he's been here. How have those phone calls been going?
They've been going okay. At first, he was upset and like regretful and like I shouldn't be here. But Isaiah, you know, he has to do a lot better. He doesn't want to go to school. He's supposed to be on medication for ADHD and aggression. It's just like it's like a whirlwind with him.
All day, every day, dude. Rudy.
Trying to run away because he wants to do what he wants to do.
Is Karen in the club?
You know, he does not want to listen. And I had him in a school to where it was with I think they're called Windmill. It was like a for kids, like adolescents, to where he would be able to go to a 6 weeks program because he wasn't suicidal or anything, but they were just gonna, you know, let him go there for 6 weeks because he's currently not in school because I sent him to Premier. He got kicked out of Premier for vaping. The school to before Lamar, he kept getting into trouble, got caught skipping one time. You know, it's like it's an ongoing battle with him. All I want him to do is go to school and stop trying to run away. He doesn't realize he can do what he wants to do as long as he goes to school, give me good grades, and ask me, "Hey, Mom, can I go here?" You don't.
Oh, is this the kid?
Somewhere. And then you take the initiative to go where you want to go because I say no, because you're not doing what you're supposed to do. And you're not cleaning up. You're not doing what you're supposed to do. And I've told him over and over and over again, you're not going to do what you want to do. You got to do what you're supposed to do. And that's go to school, keep the house clean, and be a 14-year-old boy.
Is Raymond running for Senate?
Right. Your mom is 100% right. You have 2 jobs. Until you turn 18, you have 2 and only 2 responsibilities in life.
Karen's been to Five Below and got the LED strip.
The state of Texas tells you.
Whoa.
She was in the club.
Hey now.
Everything else is bonus. But go to school and keep mama happy. And if keep mama happy means you do the dishes, then you do the dishes. If keep mama happy means you ask permission to go somewhere rather than just go off and not leave her worried all night where you are, then you ask permission. That's it. You know how many of the adults on the screen right now would kill if that's all they had to do in life is to go to school and keep mama happy. You
All
don't
we
have
gotta
to
do
worry
is
about
kill
bills.
somebody? Is that what you
You don't have to worry about going to work. You have it easy right now. Go to school, keep mama happy. That's all you've got to do. Okay? Now, part of that is she wants you to take your medication when you're supposed to. She wants you to clean your room when you're supposed to. But all things considered, Judge Porter would like to be, just have to clean up his room and have everything taken care of. But I have more responsibilities than that. You got it easy. You need to enjoy that while you got that.
He's right though.
They're going to come
I mean,
where you're going to have a whole lot more responsibility.
then all of a sudden you're an
Near as
adult.
fun. Okay? So Mama, in the last couple of days, how have the conversations been going? Have they been going better?
They've been going smooth. He's like, Mom, I really don't want to be here. And Isaiah, he's a good kid, you know, but he can run a good game.
Well, let's don't go that far.
Yeah, he can run a good game. That's what I'm saying.
Yeah.
Say something,
Okay.
he can say
So,
something, make it sound real good, you know.
If I let him go home, do you feel safe with him in your house?
I feel safe with him, but I feel like he needs something like a leg monitor.
Oh, I completely agree with you on that.
I need a stun gun, but that's about it.
You and I are
Less
you and
than
I are in
legal.
lockstep, Mom.
Yeah, he needs something
Great
like a
band.
leg monitor to where
Yes,
he can
it was.
Back in the day.
repercussions if he decides to climb out the room window or anything, because
Go
he's
ahead, mate.
at the age to where he's smelling himself and he thinks that he's gonna bogart me. And I know if I go to spank him on the
Nice.
behind, it's
Ooh.
gonna be a whole fight.
Get him.
So I'm not gonna, you know, it's like,
Mom, have you been to Home Depot recently?
They have big switches there, like
I
get
haven't been to Home
lattice.
Depot
and-
recently. Now we
Okay.
stay like in a downstairs apartment.
Well, wait. Let's stay on task.
Okay.
They sell these things that you can attach to bedroom doors and attach to windows
Ding, ding.
that are
Make a
alarms.
little.
They'll go off if he tries to get out when he's not supposed to. I'm just saying, you're the mom. You can invest in those for it if you want.
Yeah.
You know, Mom, if you feel safe with him in your house, I'm gonna trust you. You know him better than anybody else. You're on top of this, and you and I working together, we gonna help us out. Okay, I firmly believe that because you and I are on the exact same page. So I feel good about letting him go home to you. He has been level 1 outstanding for the last 3 days.
1-0, hell yeah.
And so I'm gonna authorize his release on the electronic monitor.
Whoa.
All right, Mom, thank you.
Mom convinced them.
Mama's good.
You gonna bring him back to court whenever he's supposed to come back to court?
Yes.
Yeah, they're just
That's
batteries.
what I needed. All right,
Pretty easy.
that'll be the order of the court. Thank you, Mom.
What do we got
because of the
going on over
violation
here?
of parole, which you'll be admitting today for that 2800.2 offense,
like
which is
something
a state
serious.
prison offense. Do you understand that?
Yes, sir.
I'm not going to
These are pretty
sentence you to 4 years and 8 months, and instead I'm going to follow the plea bargain and sentence you to 2 years, 8 months in state prison. Do you understand that?
Yes, Your Honor.
If you violate the terms and conditions,
She's so sweet.
but when you're released from prison, you'll be placed on parole or post-release community supervision. If you violate the terms and conditions of your supervision, you could then be sentenced to up to 180 days for each violation. Do you understand that?
Yes, Your Honor.
And do you understand that you'll be placed on 3 years of parole in each case?
Yes.
Bunch of soft touches today. Porter's letting people
The court
out.
must impose a
She's
restitution
over here
fund
taking
fine of
2
at least
years off of the
$300,
sentence.
not more than $10,000. It will be doubled if you fail to complete parole or post-release community supervision
do it, Eric.
successfully. Do you understand that?
Yes, Your Honor.
The court will impose a $40 court security fee and a $30 criminal assessment fee as well. Do you understand that?
Yes, sir.
As a result of your conviction, you'll be ordered to submit DNA samples as well as finger and handprints, which will be included in the state's DNA and forensic identification database and database program. Do you understand that?
Yes, Your Honor.
You'll be ordered to make restitution for any of the
Mike, I'm
economic
going to jump
as a
over
result of your conduct.
to
Do you understand
Judge
that?
Boyd. She has a lot of people around.
Judge Stephanie Boyd. Is she working at a window? Is she doing this part-time?
Everyone give me a moment. Tell me that.
There's somebody there to. I got to sell a book of
Is it-
stamps. Hold on, baby.
Maybe that's the magistrate's office. That's all I could think of. Oh, somebody's got a big black eye there.
That might hurt a little bit.
Or is that a birth defect? I can't tell. We'll come back when
Controlled local law
Judge Boyd comes
enforcement
back.
for selling or storing firearms with a licensed firearms dealer within 14 days of today's date. Do you understand that?
Yes, Your Honor.
A lot of conditions to go to jail for.
I will be imposing various parts of your sentence. You must state your objection before leaving the courtroom, or you will have waived your right to appeal any part of the sentence. Do you understand that?
Yes, Your Honor.
You have certain constitutional rights that you waive when you plead no contest to
That
a
was a black eye. I'm
felony
pretty sure.
offense. You have the right to have a speedy and public jury trial. at which the prosecution has the burden to prove your guilt beyond a reasonable doubt, and at which a jury of 12 members of the community would have to unanimously agree that the people have proved the case against you by proof beyond a reasonable doubt. You have a right to have a preliminary hearing to determine if there's probable cause to believe that a felony has been committed and that you are the person that's committed that crime. At those hearings, you have the right to confront and cross-examine the witnesses against you. That's the right to see and hear, and through your attorney, question the witnesses who testify against you. You have the right to present evidence and have the court issue subpoenas to bring to court witnesses and evidence
just
favorable to
sentence
you at
him
no
for the
charge
2
to you.
years?
You have the right to testify if you choose to do so, but you also have the right against
Yeah,
self-incrimination. That's the right to say nothing at all about the charges, plead not guilty, and require the people
not going to
prove your
trial.
guilt at that trial. Do you understand each and every one of your constitutional rights?
Your Honor.
Do you have any questions about your constitutional rights?
No, Your Honor.
Do you give up those rights? Your constitutional rights?
If you want to take the deal, you have to give up those rights. Yes, Your Honor.
Mr. Mock, do you join in those waivers?
Okay, that's
Yes.
what's going on.
Other than
Yeah.
what's been stated here in open
Okay,
court,
that was
and I know it
confusing
may be a
for
bit
That was-
confusing, but I think at the end we settled on what's going to happen with you. Other than what's we settled on, has anyone made any promises to get you to enter this plea?
No, Your Honor.
Has anyone threatened you or anyone close to you to get you to enter this plea?
No, Your Honor.
Have you had enough time to speak with your attorney and go over the facts and circumstances surrounding your cases?
Yes, Your Honor.
Do you have any questions at all about what you're doing here today?
No, Your Honor.
Do you understand the nature of the charges that have been filed against you?
Yes, Your Honor.
Are you pleading no contest freely and voluntarily?
Are we
Yes,
gonna
Your
hear
Honor.
And Mr.
Yeah,
Mock,
I'm
do you
like, are
consent
we
to a
gonna read his
planned change of
charges?
plea?
Yes.
Ms. Russell, could you recite the factual basis as to count 2?
Yes, Your Honor. On or about January 13th, 2022, in Stanislaus County, defendant Paul Ray Taylor did willfully, unlawfully, and feloniously drive and take a 2006 GMC Sierra pickup belonging to Felix Valverde, Felix Valverde, without the consent or permission of Mr. Valverde to have the truck, and with the intent to permanently deprive the owner of Title II and possession of the vehicle, and the value of the vehicle from the victim was between $6,000 and $10,000. And also, on December 21st, 2009, the defendant had previously been convicted of a violation of Vehicle Code Section 10851, a felony
that
in
is not
Stanislaus
a-
County under docket number 1410432.
For purposes of this plea, Mr. Mock, do you accept and agree that there is a factual basis as set forth by Ms. Russell?
Yes.
Mr. Taylor, in count 2 of the complaint, it alleges that on or about January 13th of 2022, that you committed a felony, unauthorized use of a vehicle in violation of Vehicle Code Section 10851A. It alleges that you willfully, unlawfully, and feloniously drove a 2006 GMC Sierra pickup that was the personal property of Felix Valverde without that person's consent and with the intent to deprive the owner of title to or possession of the vehicle. To that count, do you plead guilty, not guilty, or no contest?
No contest.
The special allegation pled thereunder
Prompting
alleges that the value of the property was in excess of $950. Do you admit that special allegation? Do you
Yes, Your
admit?
Honor.
All right. There is a 666.5B prior alleged.
Whoa,
It
hey,
alleges that
devil's lettuce or something.
on or about the 21st day of December of 2009, you had a conviction prior to the offense in count 2 for an auto theft violation of Vehicle Code Section 10851 in Stanislaus County. Do you admit that you had a prior conviction for auto theft as of the date of count 2?
Yes, Your Honor.
The court finds the defendant understood the nature of the crime and the consequence of his plea. I find the defendant understood
Maybe.
his rights and that he knowingly and consciously waived those rights. I further find the defendant entered his plea voluntarily and that there is a factual basis for the plea. Therefore, I find the defendant guilty of count 2, that the special allegation is true and that the prior that he admitted to is true, and that is the prior pursuant to Penal Code Section
Okay, so that
666.5.
That makes
Concerning the
sense.
balance of this complaint, is there a motion on behalf of the people?
Yes, Your Honor, the people move to dismiss the balance of the complaint in light of the plea.
And is there a motion with regard to case number CR 19-1205?
Yes, Your Honor, the people move to terminate that case as unsuccessful in light of the plea.
Those motions are granted.
All right. Well, we know what's
As they first-
happening there. Let's jump back over here.
County. And
She's
I
back.
believe
Chris
they
Saxon on the
listed
move, everybody.
the
Chris
charges
Saxon.
as being a felon in possession of a firearm, theft of a firearm. Looks like possession under a gram and marijuana.
What's going on, Jesse?
32.
Do you know who the attorney is out of county or no?
It's a Miss Hannah Hawkins. I believe she works with Texas Rio Grande Legal Aid under Sean Keen Dawes, but that's my understanding.
All right, Ms. Ferguson. Norma Ferguson.
Yes, ma'am.
Yes, on this case, can I have a 30-day reset, please?
Nope. Chris just had a creed frame.
Yes, ma'am.
He just
Your Honor,
switching
would
to
it be
Brazil right
possible-
now.
And I don't know. I'm just trying to think because we're essentially in a position we're ready to plea on Mr. Pinelli's cases. Would it be possible to bench warrant him from Atascosa so we could go on the record and get these done, or are we kind of got our hands tied until?
If Atascosa has the ability to Zoom, we could do it by Zoom.
Okay. So I will try to talk to his attorney over there. Then maybe we can get something set up.
All right, so what date, Ms. Ferguson?
Miss Ferguson.
It's in the chat.
Thank you. And Ms. Ferguson, can you see and perhaps coordinate with Mr. Slimane? Maybe we can.
What do you
sooner
got?
we
This
can
is
get-
kind of moving.
First appearance.
Attorney. Yes. How are you going to proceed? Are you going to represent yourself or get a court-appointed attorney, or what are you looking at doing, sir?
Burnett County.
I wanted to thank Mr. Davis.
Going out of pocket.
You
Creed.
want to retain him privately?
Yes, ma'am.
Okay.
Out of pocket.
All right. Have you been able to speak
Street
with
Grain,
Mr.
thank you
Davis?
for the 5 bones.
All right. Had I known that, I would have talked to Mr. Davis. I had him this morning for cases, and I would have given him a heads up so he could attempt to contact you. What we can do here today is I can we can go forward with the criminal complaint and set it for preliminary hearing, or I can set it for an adjourned initial appearance and make sure that or hope it's on a date when Mr. Davis is here, or give you time at least to contact Mr. Davis and he can get a date that works for him and his calendar. What do you wish to do here today?
I wish to name and speak to him.
And so you wish for me to adjourn this to set this?
I
to
wish to
another
go
date?
home, Your
Yes,
Honor.
ma'am.
Okay.
Can you
I
just
need
let
to
me go?
See if I can find when Mr. Davis is next going to be here. We're off the record. You can talk to the ADA.
Look at the awesome logo powered by Zoom.
Powered by Zoom.
It's almost very reminiscent to our logo up there, right? The judge is about to rule.
My assistant is looking.
Flusha, I think
Otherwise,
it is.
Back on the record. Otherwise, Mr. Oyat, if you wish to do a court-appointed attorney, I do have a very excellent attorney, very beyond competent attorney sitting in front of me right now where I could court-appoint Daniel Chapman. But I want to make sure that you,
Is that Dog's brother?
if you're going to want to retain Mr. Davis privately, that you can do that. Otherwise, I could court-appoint Daniel Chapman.
Take the
and
free
he's
one.
in
Take
front
the
of me
free
right
one.
now.
Take the free one.
I wish to retain Mr. Davis. I have experience with him.
Okay.
Okay.
You
I
had a
can
free
schedule
one.
you for April 6th at 3:30 for an adjourned initial appearance. That's his next date and time in which he'll be in front of me. April 6th at 3:30.
Yes, ma'am.
So you just hang out till then, all right? Or you could have
All right.
had this one and
Then
got
we
out
will
today.
see you on that date and time. Thank you.
Ma'am. Ma'am. I wrote a letter for a bail reduction hearing.
I'll hear it. I read your motion, Mr. Schmidt. Did you read it?
Mostly competent.
Filed a bond motion yesterday asking to not have any additional cash. He's made arrangements for treatment. Anything else?
I can afford, I have $1,000 right now. I will post that.
Baller. Got a shoebox. No shoes
You
in
have
them.
you have $1,000 right now to post on top of the other cash that you've already posted.
Yes, ma'am.
And so right now I set bond at $3,350, and you believe that you would be able to post an additional 1,000 to make it $2,350.
What I understand, ma'am, was I forfeited the first $1,000.
You probably did, or you could have done that.
That's what the bond said, that it minus from the 3,500, which reduced it down to 2,750. I asked for a bail reduction to 1,000 cash.
Got all that money.
Right?
Mr. Schmidt?
Can we drop this
Any
down, Your
argument?
Honor?
Oh my God.
I see it. Oh my God.
That phone.
It's reversed.
She wearing her green robe. Dare anybody say anything to her though? Dare they?
Not today, you don't. Oh, and she's muted.
There
Nope.
we go.
Nope, we're getting there.
She embarrassed herself. She had to fix that.
There we go.
Well, the cat's out of the bag. Judge isn't really there.
Thank you. We are adjourned.
Stay here after 6.
Oh, we
No,
got
he's
it
being
reduced. Yeah.
Only got a couple more minutes. We'll I'm not sure what's happening here. Looks like we're down to 2.
If I get anybody else in, I'll let you know.
Yes.
Yeah.
You've been expecting. Thank you very much. Yes, Your Honor. Some earplugs so that hopefully the public will still be able to hear. Claudia, I need you to interpret first appearance hearing for 2 individuals,
For sure.
and they both speak Spanish.
I've never seen it like
Before we begin,
reversed.
will you please
All right,
swear?
I got
that.
somebody if you want to jump.
Oh, I see that. Yeah, we're good. We'll wrap up on this because we got a long day today. Don't forget 405 East Wild Woman Wednesday is happening for We Got a Chase, and I believe it might be a doozy by the
It's
looks
a
of that.
doozy, baby. Just remember that. I warned you.
With Joel Larimore at 2:00.
And we will be back at
That is right, and I was
8:30
gonna
East
ask you
tonight for the
about that.
return
Apparently,
after a month
The
of
one
the
with
OG show.
Joel, apparently Joel is unable to be here. He asked to have that rescheduled, or the PD's office did. But I was going to ask you, is there a reason you're not on both?
I think the more pertinent question would be: is there a reason Joel Larimore is not on both? I think
Whoa,
he has a
easy,
revocation.
smart
And
ass.
he has an underlying case. I think I got this one because there's a conflict with him.
Okay.
So, depending on what the other ones were, I could take him over, but he's already made a lot of progress on them, I think. So my case. is
Go ahead, get your
probably
bets
just
in.
gonna
What
be
did she do?
in a holding
I'm
pattern
going
while
with
he deals with his
assault,
stuff.
Creed.
That makes sense.
But I was contacted by the public defender's office about
with her
filling
lover.
in for Mr. Larimore
Partner.
today for his case, but then I never found out what it was scheduled for or what was being done. So I can't do anything on his case today.
And it was just a status anyway. So
Yeah, I don't know what the status is.
we will go on the record in the matters 21 CM 204, 22 CM 45, State of Wisconsin versus Robin Bearhart. The state appears through Assistant District Attorney Kevin Schmidt in person. Ms. Bearhart appears by video conferencing in custody at the Burnett County Jail. We have Daniel Chapman appearing in 22 CM 45. Joel Larimore requested that 21 CM 204 be moved to another date and time, or that Mr. Chapman be able to fill in for him. However, off the record, Mr. Chapman indicated that he doesn't know the status of that case. What I'm going to do is I'm just going to have the 21 CM 204 track along with your case, Mr. Chapman. We can figure out what's going to happen and what attorney, if one or both of you will continue on these matters. To the 22 case, did you go over that criminal complaint with Ms. Bearhart?
I did, Your Honor.
Does she understand the charges and the maximum penalties?
She does, Your Honor.
Formal reading or waive?
We will waive formal reading and plead not guilty.
Bearhart Drive, Ms. Bearhart, that's still your address?
Yeah.
And telephone ends in 4069.
Bearhart Drive. He lives on a
No,
street with the
1906.
same name.
715.
What is it?
715. 431 1906.
1906.
call.
All right. Thank you. May we send you text message notifications?
Yes.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial and you would be entitled to a speedy trial should you request one. Mr. Chapman, I don't have other dates and times when Mr. Larimore will be here. Hopefully he'll be able to make.
Well, I don't think we're going to hear about this.
Yeah, I don't think we're going to hear the
your
charge.
date of
Anyways,
May 26th at 9.
as requested, we will leave with so you guys get to see your girl there. Guys, thank you so much. 2 hours of almost nonstop today. There was a lot happening. Good day in Zoom courts, as they say. Again, we do this Chases and Cases 5 days a week. Starting at 1 o'clock with We Got a Case. We'll be back again 4:05 for Wild Woman Wednesday. Again, 4:05 East. Just never forget. That was pretty spot on. Not being mean, I like
That was
them ladies from there, of course. But by the way, that phone call that we were just listening, I just figured out they were trying to call a translator. That's what that phone call was about. And I just saw the judge just doing this. Anyways, guys, we got a busy day because we'll be back again 8:30 East for the OG show, the show that started it all, the old radio show. We do things a little different over there than what we do on Chases and Cases, but we invite you to join us. I think that's it.
That is it, Creed. If you haven't already liked this video, please do so. If you haven't subscribed to our vast majority of channels, think about doing it to all of them. Share it out on Facebook if you will. Follow us because that's the best way to keep up. And until next time, and Lisa, please remember. Nailed it, Bob. Nailed it.
Hi, Bob.
See you, Bob.
See you at 4:05.